This is the 5th lecture in my series on formalities and constitution, and what I'm going to do here is take you through the way that I would approach an answer to a question on formalities and constitution. It was a question that was set to be taken as an unseen question. The student was allowed to take in their statute book, but otherwise it was closed book, and they had an hour in which to answer the question. So I'll take you through the facts, and I will be putting a copy of the question in the notes to the video. So you've got Wendy, who is the executor of George's will. George died last month and he's left all his estate to the local donkey sanctuary, and Wendy, the executor, has now discovered the following things. So first of all, that George had completed a stock transfer form to transfer all his shares in ABC Limited to Harry, and he sent a letter enclosing the share certificate to Harry, and in the letter he says, "I have no further need for these shares, do what you like with them, they're yours now." Harry put the letter and documents in a drawer in his office and then forgot about them, and he's now claiming that the shares belong to him rather than the donkey sanctuary. Another thing that happened is that George wrote to Susan saying that he decided that she and her children should benefit from SeaView, and he writes that "I confirm I'm holding SeaView on trust for you for life, and then it will go to your boys equally. I have the land certificate in the safe in my study," and we're told that SeaView is a cottage, so it's land, and the land certificate was found in George's safe after his death. And then finally, George wrote to his solicitor, "Anna, here's the land certificate for my flat in Chelsea. I want to put it in trust for my children, Beatrice and Ben, in equal shares until they're 25. You are the trustee. Please sort out the necessary paperwork." And he signed that letter, and then Anna writes to the beneficiaries, Beatrice and Ben, confirming that she would deal with the necessary formalities to complete the trust for them. Unfortunately, George dies before Anna is able to act on the instructions, but what she did discover is that he'd written on the proprietorship register on the land certificate, "I hereby transfer this property to my solicitor Anna to hold for Beatrice and Benny," and he has signed it. So what we need to do is to advise Wendy who is entitled to the shares in ABC Limited, SeaView, and the flat in Chelsea. So the first thing that you do in an unseen exam, if you have a choice of which questions you're able to answer, is that you'd go through the paper and identify the general topic for each question. So for example, is it breach of fiduciary duty? Is it tracing? Is it commercial trust, etc.? And for this one, the first thing I would note is that it's about lifetime gifts. So I'd start thinking about formalities and constitution. And then when I read on, I can see that we're given details of how the deceased attempted to carry out his intentions. So at this point, I'm pretty certain that this is a question on formalities and constitution. Once I've decided to answer this question, I then go through it, and again I'm going to make my initial notes, so I'm going to jot down my ideas. Usually I do this against the question on the question paper itself, but you can do it in your answer booklet if you prefer, or if you have to. So for each disposition, I do a quick check, is there certainty of subject matter and objects, and there usually will be, because examiners don't usually combine subject matter and objects in a question on formalities and constitution, but you do need to have a quick check. And then in relation to each of the attempted gifts, I want to work out whether they're perfect or imperfect. So for each one, I'd have a look at the intended mode, the type of property. I'd work out whether George had to transfer that property in order to perfect the gift. I'd briefly jot down the rules in order to transfer that type of property, and then if I decide that the gift is imperfect, I would jot down any possible relevant exceptions to the rule in Milroy and Lord. And the reason I do this is because you don't have to deal with each of the attempted gifts in turn. You might want to play about with the order if it works better. So for example, I look out for perfect gifts and tend to group self-declarations of trust together because no transfer is needed. If there's a particular tricky one, so there might be a nasty exception to Milroy and Lord, then I might deal with that last and get the easier ones out of the way first, so I know that I've got the credit for those in the bank. And certainly if you have time, so if it's a scene exam or a coursework question, then it is worth having a play around with the different gifts to see if you could group them together to avoid repeating yourself. Of course, you might not have time to do that in an exam. So again, these are still my notes, and I'm looking first of all for the intended mode, and I've got the crucial wording there. Do what you like with them, they are yours now. So I'll write in the margin, that's mode 1, it's an intention to make an outright gift. I'd note the type of shares, or shares in a private company, or I might just simply underline shares in ABC Limited. I know it's a private company because of the words limited. And then I'd quickly read through the facts to see if the transfer is complete, and I can see that it isn't. And so I would quickly then jot down a possible way of perfecting this gift. And I think at this stage it looks like a re-rose type exception might apply here. Then we've got SeaView, and again the first thing I'd do is work out the attempted mode of disposition. The crucial wording in the letter there is I am holding SeaView on trust, so that's a mode 3. George was declaring himself a trustee of his property. I'd note that it's land, and then because it's a declaration of trust over land, alarm bells would start ringing in relation to the formalities to declare the trust. So I'd look to see if I've got anything in writing and signed by George, which there is. And then in relation to the third gift, again, I'd start out by working the intended mode, and he says I want to put it in trust, so it's a trust. You are the trustee, so it's a trust by transfer, it's a mode 2. Again, the subject matter is land. I look to see what's happened, and I can see that the gift is imperfect, and I start looking at possible exceptions, and then I'm going to make a rough note that here it seems to be that I'm going to have to look at Pennington and Waine. So here's what I've done so far in my rough notes. I do a quick check to make sure that I've got certainty of subject matter and object, which there were. But then what I was looking for in relation to each of those dispositions is whether the gift was perfect or imperfect. So I worked out the intended mode, I looked at the type of property, I then thought about whether a transfer of that property was needed. I thought about what the requirements are to transfer that type of property, and that enabled me to reach an initial decision as to whether that gift is perfect or not. And if it was imperfect, I jotted down any possible exceptions to the rule in Milroy and Lord. And that's what I suggest you do when you're facing a question on formalities and constitution. And if you want to relate that back to what we've looked at when we looked at Milroy and Lord in the second video in this series, here's a slide taken from that video. And what we're adding to that is that we've now considered the exceptions to the rule in Milroy and Lord, so we're also going to consider whether any of the possible exceptions apply to those gifts. So now I'm ready to start answering my question, and as always I will use the IRAC method. And IRAC stands for Issue, Rule, Application and Conclusion. And the first thing I'm going to do is I'm going to set out the main issue that I need to advise Wendy about. So I need to set out the potential problem. And so I'm going to explain that what we need to work out is whether the intended beneficiaries of those gratuitous lifetime dispositions are entitled to the property, or whether the property will pass under George's will to the donkey sanctuary. And note also within that I've identified these gifts as gratuitous lifetime dispositions. So they're lifetime dispositions where the intended beneficiaries haven't provided any consideration. So I flagged up immediately that I realised that these are gratuitous lifetime dispositions. And at this stage, what many students do is they then dive into the first gift and start working out whether it's imperfect or not. But the way I would deal with it is all these lifetime gifts are subject to the principle in Milroy and Lord. So before I start dealing with the individual gifts, I would begin by explaining the general principle in Milroy and Lord, that equity won't assist a volunteer by perfecting an imperfect gift. So what Lord Justice Turner says in Milroy and Lord is that the property owner must do everything necessary to complete the gift by the intended mode, as the court will not substitute a failed transfer for a successful declaration of trust. So in other words, the court will not substitute one mode for another. Make sure that you're confident that you are able to explain the rule in Milroy and Lord before you go into the exam hall. And don't simply rely on the phrase equity will not assist a volunteer or equity will not perfect an imperfect gift. You need to be able to explain exactly what that means. I've decided to deal with the self-declaration of trust first because it's the easiest, and then I can deal with the other two gifts which require a transfer, so they fit better together. So the issue is whether this declaration of trust was valid and enforceable, and I'd quickly confirm that there's certainty of subject matter and objects, and then I would apply Milroy and Lord by identifying the intended mode, and I would identify the relevant wording to justify that conclusion for the examiner. And the relevant wording is I am holding SeaView on trust. So because it's a declaration of trust over land, the relevant law or rule is in Law of Property Act 1925, section 53(1)b, which essentially says that a declaration of trust over land must be evidenced in writing and signed by the person able to declare the trust. So that's the rule. So the next stage is to apply that rule to the facts. Well, the declaration of trust is in writing and it was signed by George, who is the property owner, so he's the person able to declare the trust. So I'm able to conclude that it was a valid and enforceable declaration of trust, so it's held on trust and doesn't form part of George's estate. I'm going to deal with the shares next because I know from my notes that I can apply the every effort rule from Rose and that I don't have to apply Pennington and Waine, so it makes sense to deal with it first. Here's a reminder of the facts on the slide there. And here's a reminder of my rough notes. And when answering my question, the first thing I'm going to do is to quickly point out that certainty of subject matter is present. It's all his shares and they're identified in the stock transfer form. And the object is clear, which is Harry. So again, the next thing I would do is identify the intended mode, which is an outright gift, and I would identify the relevant wording for the examiner, which is they are yours now. And then I would explain that in order to perfect this gift, George needed to transfer legal title to the shares to Harry. So the next point is I need to explain the rule in order to do that. So in order to transfer legal title to shares in a private company, the shareholder needs to execute a stock transfer form and send that along with the share certificate either to the company or to the transferee, and the company then registers the transferee as the new owner, and it's only at that point that legal title passes to the transferee. If we apply that to the facts, well, George did complete a stock transfer form and he sent it with the share certificate to the transferee. But because Harry didn't send it to the company, legal title wasn't transferred before George died, and I would then conclude that this gift was imperfect. Now remember that I've already explained the law in Milroy and Lord, so I don't have to do this again. But what I would do here is now explain that the next issue is whether any of the exceptions to the rule in Milroy and Lord can apply. And remember, always look at Rose before moving on to Pennington and Waine. So I'd explain the rule in Rose, which is that equity will perfect the gift if the donor or property owner has done everything within his power to transfer legal title, and a slight variation on that is Mascall and Mascall, where the transferee has all the documents he requires in order to complete the transfer of title. If I apply that to the facts, Harry did have all the documents that he needed in order to complete the transfer, so equity will perfect this gift. So George was holding the shares on a constructive trust for Harry when he died, and therefore it won't form part of his estate to go to the donkey sanctuary. Incidentally, if you like my videos, if you're finding them useful, and if you're feeling particularly generous today, why not buy me a coffee? And then the final gift, here are the facts just to remind you, and here are my notes again just to remind you, and hopefully you're getting the hang of this now. I would confirm that there's certainty of subject matter. Anna has the land certificate, so it's fairly clear which property is subject to the trust, and the objects are clear, they're named, so there's no issue. And then the intended mode is a trust by transfer, and as always I would point out the relevant wording for the examiner to support that conclusion. So I want to put it in trust, you are the trustee. Then I'd move on to explaining the relevant rule. In order to transfer legal title to an estate in land, the property owner needs to execute a deed, which is stated in Section 52 of the Royal Property Act 1925, and then the registration requirements need to be completed at the land registry. So when I apply that, well, I do have a document which is signed, but that doesn't satisfy the formalities for a deed, because for it to be a deed, the signatures need to be witnessed and it needs to state on its face that it's intended to be a deed, which this clearly doesn't. So we don't have a deed of transfer. And remember also that there was an endorsement on the land certificate itself, which was discovered after George died. But the same problem applies. George's signature wasn't witnessed and it doesn't state that it's a deed under the Law of Property Miscellaneous Provisions Act Section 1, and therefore it can't act as a valid transfer. I would then explain my conclusion, which is that George didn't transfer legal title to Anna before he died, so the gift is imperfect. Incidentally, I always welcome feedback from viewers, so if you're finding my videos helpful or if there's something that you'd like me to cover in particular, please let me know. I can't deal with individual queries in this way because it's not really the appropriate forum, but if you have any general comments about the video, then I'm always delighted to hear from you. So back to George's estate, and if you remember, we have an imperfect gift. So the next issue is whether any of the exceptions to Milroy and Lord apply. And remember, look at Rose, before looking at Pennington and Waine, but we can't apply Rerose or Mascall because George hadn't even executed the correct document of transfer. So this is where it gets tricky. And remember that you must attempt to address this issue. Even if you don't do it particularly well, do not ignore it, as I've seen some students do. So you must have a go at applying Pennington and Waine, even though it can be difficult. So in Pennington and Waine, there were 3 different reasons given for the decision in that case, and you must be able to identify which of those might be appropriate to the facts of the case that you're dealing with. And here's a tip: if you have a signed stock transfer form, deal with Lord Justice Clarke's equitable assignment first, because it's the easiest. His view was that as soon as the property owner signs the stock transfer form with the intention of transferring the shares, it operates to assign the equitable title to the transferee, and so the property owner, the shareholder, is then holding the shares on trust for the transferee pending completion of the transfer of the legal title. So if we apply that, well, there is a signed stock transfer form, and the letter is evidence that George intended to make an immediate gift, so equity would perfect this gift under this principle. However, it is a minority judgment and has been criticised and is unlikely to be followed, and you should say this. So now we've got to consider the other 2 possibilities which we find in the judgment of Lady Justice Arden. So the first one is the principle of unconscionability. A donor will not be permitted to change his or her mind if it would be unconscionable in the eyes of equity vis-à-vis the donee to do so. So in other words, things had reached such a point that it would be unfair for George to have changed his mind. So in order to apply this, you need to have a look to see what actually happened. Well, he instructed his solicitor to sort out the paperwork for the trust. He sent her the land certificate, which was his document of title. And then the solicitor writes to the beneficiaries, so the intended beneficiaries are told about the trust and confirming that she's going to deal with all the formalities of transfer. Now, you might think that in the light of that, it could be argued that it had reached a stage where it would be unconscionable for George to have changed his mind, but things have moved on since the decision in Pennington and Waine, and Lady Justice Arden's judgment was quite widely criticised, and in later cases there's been a reining in somewhat of that principle of unconscionability. And in Curtis and Pulbrook, the judge viewed Pennington and Waine as a case being decided on detrimental reliance by the transferee. And in that case, the transferee had been told that Mr. Pennington would sort out the transfer for him, and he was appointed a director of the company on the belief and understanding that the shares had been transferred to him. So in the light of Curtis and Pulbrook, it's worth saying that perhaps some form of detrimental reliance is needed as evidence of the unfairness for the beneficiaries. So if we apply that here, well, there was no beneficial reliance by the beneficiaries. They were told about the trust, but that's it. And therefore, I would conclude that this situation is distinguishable from that in Pennington and Waine, and that the principle of unconscionability wouldn't apply here. And then we have the final principle, again from Lady Justice Arden, which is that of benevolent construction. So the court will look at the facts generously to see if they can give an interpretation to those facts which would enable the court to perfect the gift. Well, even if we say that Anna had become the agent for the beneficiaries because she wrote to them saying that she would sort out the formalities, that doesn't help because she doesn't have a document of transfer, which of course in Pennington and Waine, Mr. Pennington, who was generously interpreted as acting as the agent for the transferee, did have the completed document of transfer. So he could complete the transfer of legal title on behalf of the transferees. But that doesn't apply here, so I would distinguish Pennington Waine on this point. However, what about another possible generous interpretation? So that principle of benevolent construction, remember, is not limited to cases of finding an agent, which is a common error that students make. So could the court take a generous view of the letter and that endorsement on the land certificate and construe it so as to assume that George wanted to make himself a trustee? So a possible generous interpretation of facts would be to look at the wording used by the property owner and see if you can get from those words an intention that he was declaring himself a trustee of the property, in which case, of course, there is then no need to transfer the property to trustees. So is that possible here? Well, that doesn't seem likely either, because the letter and the wording are very clear that he wants to appoint Anna as a trustee. So the final conclusion is that it's unlikely that equity would perfect the gift under the principle of unconscionability and benevolent construction. Equitable assignment is possible, but because it's a minority judgment, it is considered to be weak authority. So the flat will form part of George's estate and pass to the donkey sanctuary. And I don't know about you, but I find it quite charming that donkeys have a beneficial interest in a flat in Chelsea. So thank you so much for watching. I do hope that you found this video useful. I do work as a private tutor, so I teach land law and I teach equity and trusts. So please feel free to get in touch if you'd like more details about my services. And also please consider subscribing to my channel because it really does make a difference. Thanks again for watching. Good luck with your studies.